to Chris. SCORE is the largest network of free volunteer small business mentors in the nation. No matter what stage your business is at, SCORE has a mentor for you. You can easily request a mentor to help you start, grow, or transition your business today. SCORE's mission is to foster vibrant small business communities through mentoring and education. We aim to give every person the support they need to thrive as a small business owner. Small business drives our national economy through business formation, job creation, wealth building. Small business are critical to a vibrant community in our society. Our volunteers at SCORE give freely of their time, energy, and knowledge to help others. You will never be charged a fee for a SCORE webinar or for any SCORE service. We serve all different kinds of groups: Black entrepreneurs, veteran entrepreneurs, Hispanic entrepreneurs, and women entrepreneurs, to name a few. SCORE was the chapter of the year in 2002. During that time, 501 new businesses were started, 808 jobs were created, and about 7,581 services were provided. Because our work is supported by the U.S. Small Business Administration and a few generous sponsors, we thank our network of 10,000 volunteers nationwide. We are able to deliver all our services at no charge. SCORE Cleveland, this is the website. So you just have to go say SCORE Mentor Cleveland. If you just say SCORE Cleveland, you'll get the Guardians website. So if you're interested in baseball, that's great, but you won't get a SCORE Mentor. So say SCORE Mentor Cleveland, and that will work. Basic, we've already done that. Okay, for those of you who have phones, I want to give you a minute. If you would like to capture with this QR code the home page and also how to request a mentor, I'm going to leave that up for a full minute to give you a chance to get those links. We will show these links again at the end of the webinar. So just hang tight while we let the people who want to capture this get it. This is easier than putting a link on the screen and say, I can't copy that fast. Well, let your phone do the walking for you, and you'll be great. So just a few more seconds here, and then I will close this off and bring up Chris's material. Chris will introduce himself, tell you a little bit about him and his law firm and his practice, and we'll be off to the races. So let me close that. And let me close that file, and let me bring up the other one. This is Chris here, and what I want to do is move this out of the way. Pull that up and do this slideshow. Okay, Chris, we are off to the races. This is your opening screen. Just tell me when you want me to show the next one.
Okay, thank you. I assume you can hear me fine?
I can hear you just fine.
Good. Well, thank you, Dan. I appreciate it. So yeah, my name is Chris Corpus, a local business attorney here in the greater Cleveland market. Have a law firm over in Elyria. I graduated law school back in 2000. Been doing this for 23 years now, and have quite a bit of different experience in the law firm world. Back in 2016, I left a 30-person law firm, became an entrepreneur, just like you all are hoping to do or are already doing. Started my own law firm, and I focus on doing business and corporate work for clients, commercial real estate and trademarks. All right, great. So that's enough of that boring stuff. So why don't you go ahead and go to the next slide, please? So this is what we're going to talk about today. Business entity selection, doing business with a partner, whether you want to be a franchise or an independent business, the differences between those. Site selection, focused on whether you're going to lease a location or buy a property, making sure you're going to be able to run your business out of that particular location. Some general contract issues and some intellectual property issues. So this is kind of like this presentation's a little bit like an inch deep and a mile wide. We hit on a number of different topics, but we don't get into a super deep dive on those items. And because everyone that's attending has a little bit different experience. Some are brand new, just looking to start their entrepreneurship venture, and other people have a little bit more experience. So this is just kind of a quick overview. So next slide, please. So business entity selection. So these are the most popular options that you have. The first is obviously a sole proprietorship. Then we'll talk about a general partnership, a limited partnership, a limited liability company, and a corporation. So in the 23 years of doing this, I've never purposely created a sole proprietorship or a general partnership for someone. And why is that? And that's because you're personally liable for everything you do, whether you're operating as a sole proprietor or a general partnership. And that usually, most business owners do not want to be personally liable. Business owners do not want to personally sign contracts, leases, utility bills, obligations with vendors. Because if you're signing personally in your own name, if anything goes wrong, then it's going to be your bank account, your home, your car that are potentially up for collection. So, but a sole proprietorship and a general partnership, those are just created as a matter of law. So the examples I like to use are, you have a bakery out of your home, you're selling crafts at a street fair, anybody could do that. But ultimately, once you make something and start selling it and you get paid for it, whether you meant to or not, if you're doing it on your own, you've created a sole proprietorship. And if you're doing it with a family member or a buddy, then now you've created a general partnership. So very easy entities to do business out of, because there's no formalities involved really, because you're the business. So once I talk to someone and I say, okay, well, if you're making these cookies or, whatever it might be, someone gets sick, if you're a sole proprietorship or a general partnership, now you're personally responsible. So that's generally why one of the main reasons why someone does not want to be a sole proprietorship or a general partnership. And then when it relates to general partnerships, you're personally liable for everything you do, and you're personally liable for everything your partner does. So if you're the salesman and your partner's the cook, ultimately if the cook, or the baker, does something improperly and people get sick, you're ultimately also responsible for that, even though you didn't make the food. And so when people hear that I'm going to be personally responsible for something my business partner did, now they really say I'm not involved. I do not want to be a general partnership. The other option is a limited partnership. And limited partnerships did have their place before the 1990s when limited liability companies were available. But ultimately, there's really, in my opinion, there's really no reason to have a limited partnership now that you could structure a limited liability company in a way similar to how a limited partnership would work. So I'm not even really, 23 years I've been practicing law. I've never created a limited partnership for someone because it's sort of, in my opinion, a business entity that's really not needed anymore, because you can have a limited liability company. So, limited liability company and corporations, those are obviously the two entities that are created the most. And if I have to create 20 businesses for clients, I'm probably creating 18 or 19 limited liability companies and 1 or 2 corporations. And for the people who select a corporation, there's usually some reason for that. It's not just, oh yeah, I'd like a corporation. I want to be treated just like Walmart or General Motors, with all those different formalities. So most people, would rather have the flexible entity like a limited liability company. So then talking a little bit more about limited liability companies, they're relatively new as it relates to corporations. Limited liability companies have been around since the 1990s, where corporations have been around for hundreds of years. And so a limited liability company, the owner is referred to as a member, where a corporation, the owner is referred to as that shareholder. And with a corporation, you have a division of decision-making that occurs. You have a board of directors that makes the 10,000-foot decisions. The board of directors hires the officers. The officers are like your president and vice president, secretary, treasurer. They're the day-to-day decision makers. And then your shareholders are, only make a couple of decisions. Do you buy and sell the company? Who do you hire as the directors? Or who are, voted on to become directors? So you have these 3 different levels of decision making. And for the vast majority of my clients, the shareholders are also the directors and also the officers. So they're wearing 3 different hats. Whereas a limited liability company, like I said before, you're referred to as a member or the owner. And you can treat your business, your decision making, where all the members make the decisions. So now you've collapsed the shareholder, director, officer roles all into one role as a member. If the membership does so choose, the members can appoint or elect a manager, and that manager is the person who is similar to like a president, and that manager can make a series of decisions and having to go back to the members to make all those decisions. So a little bit different decision making to consider whether you're going to pick a limited liability company or a corporation. But the nice thing about a limited liability company or a corporation is you have limited liability. And so if that example of someone making, a baked good and somebody gets sick, as long as you haven't done something illegal or fraudulent, then basically the creditor can only come after the assets in the company. So your personal assets are not up for collection as a member or a shareholder of that limited liability company or corporation. And that's really what attracts people to these corporate entity selections, whether it's a limited liability company or a corporation, is that limited liability protection. And so the example of, okay, so if you say that I have limited liability, what do I lose if a client or a customer does come after me for something that I've done wrong? Well, it's going to be similar to you being a stockholder of Toys R Us, Kmart, one of these companies that have gone bankrupt, and so if you're a shareholder, do the creditors come after you and say, hey, knocking on your door, you're a shareholder, you have to come up with an extra $1,000 because you don't have the company doesn't have enough money to pay its bills? And the answer is no. But you have lost whatever you've invested as a shareholder. You have lost that investment in the company, and that's the same with your limited liability company or a corporation. A creditor cannot force you as an owner to come forward and bring more money to the table to pay off some creditor. So that's where you will have some businesses that you deal with, like a bank, a landlord, where they will be requesting you give a personal guarantee, because if your company cannot pay their debts, then they're not going to be able to collect if you go out of business. And so limited liability companies and corporations, there are some differences, there are some distinctions between the two, but when it comes down to it, the biggest benefit for both of those entities is, again, that limited liability protection. There is the difference in taxation. So when limited liability companies were created, the IRS said, the tax structure of limited liability companies is complicated enough, or the tax structure in general is complicated enough, and we're not going to create a separate tax designation for limited liability companies. So limited liability companies get dumped into pre-existing tax boxes based on how many owners the company has. So if the limited liability company has one owner, then by default you're taxed as you're a sole proprietorship. Again, only for tax purposes, not for liability purposes. If you have more than one owner, then by default, you're taxed as a general partnership. And then the limited liability company can make the sub S tax election if they so choose. As a corporation, by default, you are taxed as a sub C corporation. And the C status means that your corporate entity itself pays tax, and that's that lower corporate tax rate. And being taxed as a C also has double taxation built into it, because you pay tax when you earn it, and then you pay tax again when you make a dividend distribution to yourself. But a corporation can also make the S election, and the S election is a pass-through election. And that's the same election that a limited liability company can make. And your corporate entity itself does not pay tax. All the income taxes, profits, losses flow through to your personal tax return, and then you pay tax off that personal tax return. So you do not have double taxation in the situation if you make the S election, or if you're taxed as a general partnership, or you're taxed as a sole proprietorship. But there are better, it's an accountant question. Which is going to make most sense for you. and how you're going to be taxed. So, it is always important whenever you make a business decision, there's always usually some tax ramification to that. So I work very closely with the accountants for the clients, setting up the business, should it be a limited liability company or corporation? Are we going to be making the S election? If it's a limited liability company, do we want to be, a sole proprietorship? Do we want to be taxed as general partnership? So you really do want to work closely with your tax professional and your lawyer. And so the S election, there are limits on when you can make the S election. You can only have one class of stock. You cannot have common and preferred stock. You cannot have any non-foreign or you cannot have any foreigners. You have to be U.S. citizens basically to be able to make the S election. So if you're going to have someone from another country that's going to be remote and help you with your business, whether they're in England, Canada, Mexico, you name it, then you will not be eligible to make the S election if they're an owner. So you would then be, if you don't want to be taxed as a C corporation, then you would want to be a limited liability company, get taxed as a general partnership. So you do have some of those initial tax questions that you have to answer based on who your owners are going to be. And then with the corporation, like I mentioned before, you have directors, you have officers, you have your shareholders all making different decisions based on the operations of that particular business. You can go ahead and go to the next slide. Now, and then ultimately, one of the biggest issues that I face with my clients is doing business with a partner. So I have a lot of clients, they come in, they say, this is my idea, this is, my thought, this is what the business I want to run. And then they're all of a sudden at some point in time, they're like, yeah, I want to bring someone in as a business partner. And my first question is always, why? Why do you want this person to be a business partner with you? And a lot of times they're like, they're a good worker, they're a hard worker. I'm not paying them as much as they would normally get if they were out and, at a different job, and I want to reward them for that. But I'm always like, is this person partner worthy? And, because once you make them a partner, it's really hard to make them an unpartner. Or like whether you make them a member of your limited liability company or a shareholder of a corporation, makes it very difficult. You can put provisions in the agreement to say, if you're no longer an employee, you have to get your ownership has to get redeemed, but once they're an owner, usually very difficult to make them an unowner, to redeem them. And plus, if they're a 2% owner, 1% owner, or 40% owner, they're a minority owner and they have minority rights. So many times, business owners, when they're the sole owner, they're used to, running expenses through their company that, maybe they wouldn't want to run through for another business partner. But if you're paying your car through the business, through your phone, dual trips where you allegedly have a business trip, but then you tack on vacation days, all these different things, now you have to be offering these same to your business partner. Otherwise, you're going to be found to be breaching your fiduciary duty to that minority owner. So, there's ways that you can compensate and reward good workers without having to actually make them a shareholder or a member or an owner of your company. And usually, the example I like to give is, okay, so you want to make this person an owner because the person is always looking at the good side, but this is like a Clint Eastwood movie, right? You have the good, the bad, the ugly of ownership. Not all, the ownership, being an owner of a company always isn't good. Sometimes you're like, oh boy, we got a capital problem and we need, an extra $20,000. And if you're a 40% owner, that means you got to come up with, $8,000. Are you really going to come up with a capital call with $8,000 for my business? And usually when this potential owner is that reality is mentioned to them, they're like, oh yeah, I'm not prepared to put any money in your business, but I sure will take a profit distribution. And so if the person isn't willing to put money up if times are bad, there's ways that you can give alternative employment compensation to that person to reward them, bonuses, potential distributions when you make a profit distribution to yourself and things like that. So there's ways to reward employees without having to make them a full-blown owner in your company. And when you do have a partnership, whether it's two, three, four, five owners, you really have to understand who's going to be doing what jobs and what tasks on a day-to-day basis. Because if you have two chefs and you have a bakery, you both can't be cooking. Someone's got to do the front of the house, someone's got to do marketing and sales and ordering. Not everyone can always just be baking. So, you do have to have a very good understanding of who's got what roles, who has what responsibilities. Even a business partnership is no different than a marriage. And what's the percentage of marriages that end in divorce? About 50. And what are the percentages of business partnerships that end because of the disputes between owners? It's about 50. Right. So I mean, you really have to be careful going into business with a partner. And when, as a generalization, when marriages have trouble, why is it? You know, Different expectations, lack of communication, no different in your business. You know, if you ultimately have, you know, entrepreneurs, business owners, and you're young, you have your whole life in front of you. And so what you think of as I'm going to spend my whole life in doing this business, next thing you know, you get married, you have kids, someone gets sick, you move away for another opportunity, and you don't have as much time as you used to in this business. So, you do have to be prepared for changes in the dynamics of that business and how are you going to address those. Um, and so that's why I do think that, the partnerships that I have, and when I say partnerships, I'm not talking about a general partnership. I'm just saying more than one business owner. Generally, they're the skills that they both have, that the partners have, are complementary. They're not overlapping. So one is good at the numbers, one's good at the administrative side of things, one's creative. They're not both trying to, be in each other's business and do all the same tasks. They do have a good division of who's going to be doing what tasks throughout their business day. And then I have this last bullet point in here about financial considerations, because I kept having a client say, hey, I got an investor. I got this investor. He's going to invest in my business. And I'm like, okay, how much percentage ownership are they going to get? They're like, none. I'm like, then what are they doing? They're like, oh, they're going to give me money. I'm like, well, do you have to pay it back? Oh, yeah. I'm like, well, they're a bank. They are not an investor. To me, an investor is Shark Tank. I like your product. I'm going to give you $100,000 for a 20% ownership stake in the company. And if your company fails, then I don't owe you any money. My investment is zero, or it's worthless, I should say. So, you do want to make sure that you understand, if you have to pay the person back, whether the business succeeds or not, then that person is not an investor. That person's a lender. An investor, in my opinion, is someone who invests money in your business. They get an ownership stake back, and they only get paid if your business is successful. If you're going to be borrowing money from a family or a friend, I think that you should always have these things documented in writing. But family and friends, even doubly so. Because you don't want to, a family member or a friend give you money, and the next thing you know, you're wearing the best clothing, you have a new car, you have a new phone, whatever it might be. And they're like, where did you get all the nice stuff? You're like, don't you remember? You gave me 15 grand. You're like, that was for your business. Well, I got to look good to run my business, or they are doing very well. And the person never, pays the other, the family member back. You're like, well, you're doing well now. You have extra money. He's like, oh yeah, I'm rolling in money. You're like, did you want to pay me back? You're like, oh, you never asked for money back. And you're like, but it was assumed when you had the money, you were going to pay me back. Well, you never asked for it. And so you really, then, now you're not going to have fun at family affairs anymore. You're maybe going to have a falling out. So if you're going to borrow money from a friend or a family member, and obviously anyone, you really want it to be clear, repayment terms, when you're going to repay. It could be, hey, don't pay me until you start making money. Don't pay me until this event happens, or you graduate from college, or whatever it might be. But you do want to have some sort of understanding and expectation as whether payments will be made. Or is this truly a gift? And if you make it big, pay it forward. Help someone else out. I don't need that money. It was there for you, and I'm happy to help you. But ultimately, make sure that you help someone else out when they need it. So, but ultimately, everyone's on the same page then. All right, next slide, please. And then franchising or independent businesses. And I have both. Obviously, I have more independent business owners than franchises. But like today, I just had a franchise business owner. They sold their business and they just closed today. So it's really, it's like going golfing. right? You don't go golfing with one club in your bag. You have all these clubs in your bag for all these different shots that occur. And that's the same thing with these independent businesses or franchises. So franchises, I think they do have their place. But in my opinion, as a generalization, you really can't be a real creative person, if you want to be a franchisee. And why do I say that? It's because you agree that you're going to follow the franchisor's operations manual, right? The franchisor is going to say, this is how you run the business. Here's an operations manual. Here's how you start your day. Here's how you unlock the store. Here's how you advertise. Here's where you place the furniture. Here's your recipes. And you can't deviate from it. And if you deviate, you're going to get in trouble. And so, but if you are, willing to follow their rules and, run their business as they tell you to, you're probably going to be successful, because they've worked out all the kinks. And the franchisor has dealt with all the mistakes and the U-turns that need to be made when something doesn't work out. Like you may say, hey, this is going to be the greatest and best customer management system, and then you're like, wow, that really didn't, I need one more functionality and they can't offer it, so now I gotta, that was wasted money. I'm going to have to get a new customer relations management system or whatever it might be. So but franchisors, they're not all built the same, right? You really have to understand how long the franchise has been around, how many franchisees they have, what kind of support network do they have, talk to other franchises, are franchises closing, are they growing, are they in your area? So, there's different franchise fees that you have to pay up front. So you really want to understand that franchise itself. And there's actually a franchise that's a franchise, that helps you find franchises. And it's called FranNet. That's just one of them. The funny thing is that they're a franchise, and they put you through like a personality test, to figure out what your business experience is, your management experience, your, business acumen, and then ultimately match you up with franchises that are going to ultimately, complement your skills that you currently have or supplement the skills that you don't have. So there's a lot of options out there if you are interested in being a franchise. And quite frankly, the breadth of franchises is shocking. The amount of the number of different types of businesses that you can operate as a franchise, it's almost limitless. But then again, if you do want to, you like to tinker, you like to change, you like to, always be experimenting and trying the next new thing, then that's where the independent business comes in. First, you don't have to pay that upfront franchise fee. You don't have to pay between 7 and 14 or 15% of every dollar as a royalty to the franchisor. And now this is your business, and you can run it as you see fit. And will you make mistakes? Always. But it's your business, and you're not accountable to anyone, which is a good and a bad thing. But ultimately, the vast majority of my businesses are independent business owners. Many times, these individuals, they were working for a company, they decided to leave, start their own business, build their business or their own little empire into what they want it to be, because they think that maybe there's another way to offer the product or service, whatever it may be. And so, there's really no right answer. It's what's going to fit for your situation. But you have to be careful with the franchise. As part of the franchise agreement, there will be a non-compete. So it's not that you're going to say, I'm going to work in a franchise for 5 years, I'm going to terminate my franchise, or I'm going to let the term end. Then I'm just going to know that I'm going to let them train me, and then I'm going to go out and start my own business. And there's going to be a non-compete in there because obviously they don't want that to happen. They don't want to train you and then turn you into the franchisor does not want to train you and then turn you into a competitor. Okay, next slide, please. So site selection. There's a couple of slides for this, and I think it's super important. Whether you're going to lease a location or you are going to buy a piece of property to run your business, you do have to contact your local zoning department and ask them, give them the address, and say, can I operate this business at this address, this location? And zoning sometimes doesn't make sense. It's not intuitive sometimes. Just because you can operate one business on one corner doesn't mean you'll be able to operate it on the other. And just because a current business is operating out of a location doesn't mean you'll be able to operate the exact same business out of that location, because the other business, the prior business owner could have got a variance, and that variance only applies to that current business owner. So it's always, especially if it's a smaller city, just drive over and go in and talk to them. They're more than happy to talk to you and help you. And if it's not the right location, where could you operate that business? If it's a bigger city, sometimes it's a little bit tougher, just to get in touch with someone just because they're so big. But I always recommend, if you can walk in and talk to a city official, there's always a benefit to that, putting a face to a voice and actually talking to someone. Generally, they're more than helpful, and they never want you to be an enforcement problem where they find out you're operating a certain type of business in a certain location, and now we got a problem. So you do want to check those issues out beforehand. Like, I had a client, they're like, oh, I'm going to operate this business in this location. My real estate agent said it's going to be fine. It's zoned, XYZ type of zoning. And I'm like, I don't know. I think I would give the city a call. I don't think that business is going to be able to operate there. And ultimately, no, the business wasn't able to operate there. It was going to be a drive-through only location. And the drive-throughs had to be, in a certain part of the city, and it wasn't going to be allowed where the person was looking to put it. So it's just a one quick phone call, and you can really save a lot of time having to try to deal with finding a spot, getting really interested in it, lining up architects and all this other stuff. Then you find out, oh yeah, no, I can't run my business out of that location. Heaven forbid you sign a lease that you can't break because you don't have a contingency in it. So okay, next slide, please. And then some specific lease issues. So if you are going to lease a location, my experience has been someone will go, oh, this is a standard lease, and there's no standard lease in Cleveland. All these provisions that are on this slide are going to be in your lease, but I've never seen two leases that are exactly the same. Everything is a little bit unique to the location, to the landlord, to the tenants, to the other tenants that are on the property. So when someone says this is a standard lease provision, I have not found that yet. There may be typical provisions. I was talking to someone, it was on a business transaction. They're like, oh, this is market, this is standard. And I'm like, yeah, it's standard that this issue is discussed and negotiated in every transaction, but it's not that it's handled the exact same in every transaction. So, but anyway, so we have term and renewals. Your lease obviously will always have a term. It could be 6 months, a year, 3 years, 10 years, but there will be a term set forth in your lease. And you want to see if you want to have automatic renewals, that the landlord does not have to approve of the renewal as long as you're not in default. The tenant has the absolute right to renew. And then the trick is, what's the rent going to be in the renewal terms, and you can try to negotiate that in advance. Then your rent generally will have, some combination of monthly rent, percentage rent, and CAM. Generally, every lease you're going to be paying monthly rent. That's how much am I going to pay you every month for the privilege of renting space from you. CAM, that's your common area maintenance. That's either going to be built into your monthly rent, or it's going to be a separate charge. And it'll be specifically based on the cost and expenses that the landlord has in operating the common areas. And so what's a common area? Sidewalks, parking lot, cutting the grass. If you're in a kind of almost like an office building, you probably have a vestibule and entry. You might have elevators, you have a common walkways, you might have common restrooms that all the tenants are able to use. So those areas need to be lighted, heated, cooled. And so those are all your common area expenses. And that the landlord will say, either give you a price or $1 per square footage amount. But it generally is pretty clear in the lease if you're going to be paying common area maintenance, or it might just say that common area maintenance is part of your monthly rental payment. So that just means that the landlord has figured out how much they charge, how much it costs to run the common areas, and they just charge you, just make up a number, an extra $50 a month as part of your monthly rent to compensate the landlord for that common area expenses. So you're paying for common area expenses one way or the other. It's either just part of your monthly rent, or it's a separate charge per month. And then usually at the end of the year, there's a true up to see if the actual amount you paid was right on, above, or below what was the actual costs incurred. And then percentage rent, that is generally in addition to your monthly rent. And your percentage rent means that you're going to pay the landlord a percentage of your revenue is going to be paid to the landlord as additional rent. And so when is percentage rent typically charged? It's going to be generally in a mall setting. Great Northern Mall, South Park Mall, Legacy Village, Crocker Park, something like that, where the point of the percentage rent comes from is that the landlord is actually doing things to drive customers to the facility. Santa Claus, Easter Bunny, concerts, 4th of July, all these different kind of events where the landlord is doing things to draw customers to you. And because the landlord's doing things to draw customers into the location, other than just the mix of the tenants, then the landlord is like, hey, I should get a little bit of your rent, a little bit of your sales as a percentage for additional rent. So that's usually, it's going to be very difficult to negotiate away percentage rent if you're in a mall setting. But if you're just in a no-name strip mall, generally there would be no percentage rent that's charged. Triple net lease. This is landlord expenses that the landlord is asking the tenant to contribute to. So typically the landlord, has the property taxes to pay. And so if the landlord could say, hey, I want the tenant to pay their pro rata share based on the number of square feet you release in comparison to the total potential square footage to be leased. And you're going to pay your pro rata share of the landlord's property taxes, of the landlord's insurance to insure the property in case of a fire, and possibly even the landlord's costs to maintain and repair the exterior portions of the building. So if you're in a triple net lease situation, you're in a pretty nice location. You're going to be in a Class B, Class A, property. People are going to be desiring to move into that location. If you're in that no-name strip mall, more than likely the landlord's not going to be able to justify a triple net or even a double net or single net, which we'd be paying for one of those, the property tax or the landlord's insurance. So you do want to double check that lease to see if that, and again, if you read through the lease, you'll see it should be pretty clear that, those are costs that the landlord's trying to get the tenants to pay. But again, if you're going to be in one of these really nice locations, a brand new kind of strip center that got built, that's very nice, Crocker Park, Legacy Village, and Avon Commons, whatever it might be, you're probably going to be some sort of triple net or double net as part of that, because they can demand it, because the tenants want to be in those locations and generally have very low vacancy rates. Landlord responsibilities and tenant responsibilities, those go hand in hand. If something breaks or fails in your leased location, someone's got to pay for it. And so these provisions are usually right next to each other in the lease. And generally, if the lease doesn't say that the tenant is specifically responsible for it, then usually by implication, then the landlord's responsible. And it could be repair, maintain, replace. So you really have to look to closely to see what your obligations are going to be. Typically the tenant should be repairing. Typically the tenant should be maintaining. Generally the tenant is not replacing things. The tenant, a replacement is a capital expense. And a cooling system could last 15 or 20 years. And if you have a 3-year tenancy, should you really be paying to replace a furnace that's going to last 20 years and outlast your tenancy? The answer is generally no. And so you really want to be careful. And the heating and cooling system are the banes of tenants' existence. You really want to make sure you understand what your responsibilities of that are going to be. And so, you can try to, negotiate in caps, as to the tenant's maintenance and repair responsibilities, to say, hey, the tenant's responsible for the first $1,500 of maintenance and repair costs per year. And then after that, it's going to be the landlord's responsibility or whatever that potential number is. But you do want to really, understand what your responsibilities are going to be. And then the problem is if the tenant's supposed to maintain and repair, but the landlord replaces, you want to make sure that the tenants and landlords responsibilities are in sync, because you don't want the landlord to go, no, tenant, just keep repairing, just keep repairing, just keep maintaining. And you're like, well, the tenant's like, landlord, you really need to replace it. You're like, no, just keep repairing. And so you want to make sure that the incentives for both parties are equal. Personal guarantee, like I mentioned, in the first slide, you set up a limited liability company to corporation in order to limit your personal liability, but the landlords and banks know that, so that if your business fails, you may still owe some time on your lease. And so, the landlord's not going to be able to collect against your company once it's closed. So they may have a personal guarantee in there, but you really have to be careful, when you're looking at the personal guarantee and how long it is. Is it for the first term? Does the personal guarantee go away on your renewal term if you're not in default? Should the personal guarantee only be up to the amount that the landlord improves the space with tenant improvements? So you do want to, really look at that personal guarantee and see how much as a tenant you can minimize it, especially in that commercial setting. Signage, where are you going to put your signs? Behind you. Are you going to be on the monument? Can you put a sign above your front door? So what you're going to put signage in the windows. Sometimes, landlords get really worked up about their windows, not liking signage on the windows. They like people to be able to see in on and see that there's a lot of activity. The landlord likes people to be able to see in the locations to see that there's a lot of activity. So if you have your sign package and what you're going to want to put up, you want to get the landlord to agree to your signage, in my opinion, before you sign your lease. That's your time when, as the tenant, before you sign your lease, that's the time you have your most bargaining leverage. Once you sign your lease, now the landlord, generally want to work with you. They want you to be successful, but the tenant's greatest leverage is before the lease is signed. Restrictions and covenants, very important. You want to know that if there's any restrictions on what you can or can't do or sell at your location, if there's a Starbucks or a Dunkin' Donuts in the strip center, you're probably not selling coffee or baked goods. There's probably a restriction that says, you're not going to be able to sell that as long as it doesn't equal a certain percentage of your volume. So you want to check, to see, am I going to be limited on any type of product or service that I can sell? And covenants, you could ask the landlord, hey, I'm going to ask that you're not going to allow any other business that's similar to mine in this strip center. I have enough competition in the city. I don't need it right down the street or right down the strip mall. So you could also ask for a covenant from the landlord that they are not going to also lease to businesses similar to yours. Okay, next slide, please. So general contract issues. The biggest thing is, every provision in a contract means something. It's not there to be a paperweight. So you have to understand what you're signing. And if you don't understand it, that's where the attorney comes in to be able to explain it to you. And so you really want to, if you sign something with a blank in it, that means the other party can fill it with whatever they want. You sign a contract with a blank in it at your peril. And a lot of times contracts are there to allocate risk. Who's going to be responsible if XYZ happens? Warranties, refunds. Who's going to be responsible if this happens? So that is a purpose for a contract, is to try to say who's going to be responsible if a certain scenario occurs. But really, what I think is the most important is your statement of work, deliverables, and your compensation. That should be the meat of your contract. Saying, what am I going to do for you? When am I going to do it? How am I going to do it? What type of guarantee of any type am I going to give? So that's really the point for, in my opinion, that needs to be crystal clear as to, what you're going to do for your customer. You should be able to read it to your fourth grader, and they're going to go, oh yeah, no, I know what you're going to do, mom or dad. This is what you're going to do. So there should be no second guessing. There should be no interpretation. There should be no implied. It should be very clear, what you're doing, when you're going to get paid. One of the biggest things I see is that when customers take down payments and then, expect a payment at the end, that payment at the end should be very, very small, 10%. And they're like, oh yeah, they pay me 1,000 down and 9,000 at the end. I'm like, oh, that's a disaster, right? I mean, they should be paying you 1,000 down, and then there's some progress payments, and then, the last payment should be $1,000 or something like that, to say that everything's good, and you're going to complete the job. So, you really want to, be careful as to, back ending or backloading payments, so that if a customer, doesn't pay, then you're only out that 500 or 5% or 10% and not 50 or 60%. So really, think closely about, how you're going to get compensated in the terms of that compensation. And then boilerplate provisions. If you read enough contracts, you're going to see that at the end of every contract, there's all these same provisions: governing law, waiver, counterpart and signature, and all these, and so, those all have a purpose, and they don't mean something until they mean something, until you have to go back through and say, okay, if there's a dispute, where's this dispute going to be handled? You're like, oh my gosh, I'm doing some business with someone in New York, and I got to go to New York City to file a lawsuit against this person. This is a disaster. You might not be able to negotiate it out, but you at least need to know going in, do I really want to do business with this service provider that's out of state in California? Or can I find someone that can do a very, very, very similar service and they're right here in Northern Ohio, that if I do have a problem, it's very easy for me to get restitution from them. So just because you can find someone online, like someone did that, they found someone online to do some web service. And I'm like, why? I mean, you couldn't have found someone from the greater Cleveland area to do this work. They're like, oh yeah, I found them on the internet. I'm like, but you couldn't have found someone on the internet closer? They're like, well, I never really looked much. I go, well, now you got a clown show on your hands, because now you're having to enforce this contract against someone in Arizona. As opposed to, could you have just found someone that gave a very similar service for a very similar price locally? It just makes it a lot simpler for you, for customer service reasons, to know that they're legitimate. If you have a dispute, they're down the street from you, in a court nearby. So these boilerplate provisions, while you may read them in all your contracts, they do have a meaning. And again, a lot of times you just gloss right over them until that issue actually comes up, and you're like, okay, now what do we do? And you go back to that provision. You gotta go, oh boy, I didn't know what that meant, or something like that. So, okay, next slide, please. So we're getting into some intellectual property issues. Very important. Every business is going to have some intellectual property issue. It might not be a copyright, it might not be a trademark, it might not be a patent, but you sure have business information that you think is going to be that should be maintained as confidential. So I think these are important. And a lot of times, your business, hey, I got this unique idea and it's going to differentiate me from my competitors. So you want to make sure that it's, kept confidential. So we're going to talk about non-disclosure issues, patents, copyrights, trademarks, and maybe just quickly touch on licensing. Okay, next slide, please. All right, so non-disclosure issues, you have non-disclosure agreements, or NDAs, non-compete agreements, and non-solicitation agreements. So a non-disclosure agreement, or an NDA, that should be with every vendor that you do business with every employer, independent contractor you have. There should always be some sort of confidentiality provision that, any information that you disclose, that has some sort of unique, value to your business, should not be ending up on the internet somewhere, or being used for some other purpose that's for other than, with another company, and it's not for your benefit. So you should always have these confidentiality provisions before you start disclosing ideas or discussing marketing strategies or pricing, whatever it might be. You should always have these confidentiality provisions that your vendors, distributors, employees, independent contractors sign. Non-compete agreements, non-solicitation agreements kind of go hand in hand. Non-competes and non-solicitations, they're both enforceable in Ohio. Non-compete agreements, I'd have to say they're disfavored. Across the country, more and more states are prohibiting non-compete agreements as restrictions of trade or restraints of trade. The Federal Trade Commission is trying to ban those by a regulatory matter nationwide. There's actually, if you do a search, you'll find that there is discussion of them, the FTC wanting to do that. I think it oversteps their authority, but that's where this is going. So just because you have a non-compete agreement and someone signs it doesn't automatically means it's enforceable. This Ohio Supreme Court has a test that, this non-compete, the provisions have to be reasonable to be enforceable. Personally, I'm not a huge fan of non-compete agreements. I think they're very difficult to enforce. And it causes a lot of angst between both the employer and the employee or independent contractor once upon separation. What happens if you're going to have an existing employee or independent contractor sign it and one refuses to sign a non-compete agreement? Do you fire them? So non-compete agreements is there a place for them? Sure, but you just be very careful going forward and saying, I want everyone to sign this, because sometimes they're difficult to enforce. But non-solicitation agreements, I'm a big fan of those. So a non-compete means if you leave my employment and for any reason you can't do your job within a certain number of years for a certain number of years within a certain radius of my company. Where non-solicitation goes, you can go out and compete. You can work for a competitor. You can start your own business. Just don't contact my clients. Just don't steal them. And so that's why I'm a big fan of non-solicitation agreements, because you're not restricting someone's ability to do a job. You're just saying, if you're so smart and you can do this on your own and you think I'm a horrible employer, then build this business up on your own. Don't try to steal my customers, and do this on your own. So I'm a big fan of non-solicitation agreements, because if someone does want to leave and someone does want to, conduct their business, they should be doing it and not stealing your customers that you entrusted them with. Okay. Oh, and then for non-compete agreements, non-solicitations, they have to be reasonable in time and space. So the number of months, probably between 6 and 18 months for a non-compete. You could probably go a little bit longer for a non-solicitation, 12 to maybe 36 months. Probably that even 36 is long. And then for the geographic area, it's generally the area where you do business. It can't be nationwide if you're doing business in, Cuyahoga County. So it has to be reasonable time and space. Okay, next slide, please. So now patents. Patents are federal law. States cannot grant patents. Patents are granted by the U.S. Patent and Trademark Office. Generally something that's an invention, discovery, something that's going to be novel. Filing fees are not great. They're not, the filing fees are not huge. It's, hiring a patent attorney to assist you. That's where it gets pricey. But ultimately, if you like, hey, I got this new idea, this is going to be a differentiator. The big boys aren't doing this. I'm doing this. And that's why people are going to want to come to my business. Then if it's going to be that big of a deal to your business, which generally patents, potentially are, you really need to, and I'm not a patent attorney, but you really need to hire a patent attorney to make sure that you protect yourself as much as you can. Because if you're going to be in a space where there's large multinational companies, they have patent attorneys on staff, they have engineers on staff, and they're going to look at your patent and they're going to figure out however they can get around it. So, you really have to, if you think this is a big deal, then you need to treat it as such, in my opinion, and hire a patent attorney that's experienced in that area of law to help you. Okay, next slide, please. Then we have a copyright, and then the next slide is, you don't have to go there, but the next slide is trademarks. And people, sometimes my clients get confused between the difference between a trademark and a copyright. So a copyright, that's filed with the U.S. Library of Congress, and it's some sort of work of authorship, like a painting, music, lyrics, a poem, a book, could be content you write in a blog. That's going to be things that are subject to a copyright. Copyright, the filing fee is very low. And that's one area of law that I suggest clients give it a try. Try to see if you could submit your copyright on your own. Pretty user friendly to submit copyrights. But if you do have questions, there are attorneys that they do a ton of copyright work, especially if you're looking at possibly using someone else's work as part of your work, licensing and all these other things. So you really want to understand what you're using. Be careful with clip art. You want to make sure that if you are getting images off the internet, that they actually are common and free, and you're not taking someone else's image. Name, image, and likeness, big deal. Etsy, people that are famous that have copyrights, they do regularly patrol that to make sure people haven't stolen other people's copyrighted work. So, but that's what a copyright is. It's, think of a song, think of a book, things like that. And then next slide, please. So trademarks. So trademarks are what, again, you can have a federal trademark by the U.S. Patent and Trademark Office, or you can get a trademark, and that's going to be good for all 50 states, or you can get a trademark issued by the Ohio Secretary of State, and then that'll be good just for the state of Ohio. But a trademark is a source identifier. And you're like, well, what does that mean? So a trademark is your golden arches, your double D for Dunkin' Donuts, that weird looking mermaid for Starbucks. All of those are what, as soon as you see that, the Nike swoosh, the little baby alligator, as soon as you see that, exactly who made it. Is it a quality product? Is it a cheap product? Is it a popular product? In your mind, all these images come flooding when you see that. You're like, oh boy, that person wasted their money, or you're like, oh wow, that person's cool, they're on the cutting edge, whatever it might be. But that trademark is a source identifier. And when you do pick your name of your product or service, whatever it may be, then you have to look and say, okay, how do I want to market this? Do I want to try to have that same name across all my platforms, domain names, social media names? How am I going to ultimately further market this particular product? But again, that trademark, I have clients now that they end up, so many trademarks have been taken, so many words have been taken. People are starting to, spell their names backwards. It's really difficult to find a unique name. Um, and generally, so then you're like, okay, so what's a strong trademark? So if you say the name of a product or service, and you're like, wow, I wonder what they do, great trademark. Made up words, great trademark, because then you get secondary meaning. So then you look at Starbucks, Nike, um, Microsoft, all these words that generally meant nothing, and now they're iconic, and because they had to get secondary meaning. But if you have something that's like fruit stand, you're like, oh boy, you know, that's generic, that's descriptive. If because when you hear that, you're like, oh boy, I'm going to go there. It's going to be a roadside stand. I'm going to buy fruits and vegetables there. So there's no trademark value in that. But ultimately, if you use it in a different way and you use fruit stand as a line of clothing, you're like, oh, okay, I didn't think of that. So that is a good name, but you can't keep everyone from using the word fruit stand, because they really might be selling fruits and vegetables on the side of the road. But no one else will be able to use it for a clothing line. So trademarks can be kind of confusing as to what's a good name, but my general rule of thumb is, if you say the words and it conjures up an image in your head of what that product or service is, it's going to be descriptive, and you may have no trademark value or very limited. But if you say the words and you're like, wow, I wonder what they do, great trademark. But now you have to spend money to educate customers as to what you do. So I do get it. There is a value to Chris's Lawn Care, right? You see it on the side of my truck, you hear the name, you're like, oh boy, I guess he makes tall grass short, right? No marketing necessary, but I can't keep Bob, Sue, or Jill from having Jill's Lawn Care, because it's descriptive and it has their name in it. So, and also surnames, cannot use your last name as a trademark. Everyone has the right to use their last name to operate a business if they so choose. Okay, next slide, please. And then licensing. So this is what generally you do with your intellectual property, whether it's a copyright or a trademark. You have the ability to allow others to use your intellectual property, even a patent. But then this license will grant the right to use your intellectual property, patent, copyright, or trademark, or it'll put limitations on it. Maybe you can only use it on certain products. Maybe you have the right to do quality control and come in and check how it's being used. How long is the license? How much are you getting paid as a royalty? So all these different things in your licensing. So it is important. I don't have a ton of clients that are, if you want to say, popular enough where they're actually licensing their intellectual property. More than likely, my clients are licensing someone else's intellectual property. But you want to understand the terms of that license agreement to make sure you understand what rights you have and what rights you don't have. Okay, I think the next slide, and then that is it. So like I said, this is like an inch deep and a mile wide, gives you a ton of information, and make sure, hopefully, raises some issues for you to think of, to say, okay, yep, I'm already doing that, or nope, I'm not doing that. Or, get you some questions to think about, or some things to review. So there we go.
This is Dan Newman again. We're going to take some questions in the chat. If you'd like to put your questions in the chat, Chris can come back with his smiling face here and respond to them. If there's any questions, just put them into the chat, and we'll see if we can't get you an answer. Is a recorded program going to be available at SCORE? Yes. In about a week, you will be able to see the recorded program on YouTube and also on the SCORE website. Everyone who is registered will get a copy of the slides. So you'll have that as well. So I hope that answers that question there.
I guess I do have one other point. The federal government, a couple of years ago, they passed a new law called the Corporate Transparency Act, and that goes into effect, unless it gets continued, it goes into effect January 1st, 2024. And every small business, it's meant for small businesses, every small business is going to have a filing requirement with the federal government to disclose who the owners of the company are. Anyone who owns 25% more of the company needs to disclose their information. The person who signed the paperwork to create the company, the organizer or the incorporator, has to be disclosed. And there is a fine if you don't timely file that. So if your business is in existence on December 31st, 2023 or earlier, then you have all of 2024 to file this, submit this filing. If you create a new business on January 1st, 2024 or later, right now, you have to file this information within 30 days of the filing of your company, but they have submitted a rule wanting to extend that to 90 days. So I don't think it's super duper onerous, but it is ultimately something that every single business owner, including myself, is going to have to comply with in the year 2024. And you also have, as part of the information that you have to disclose, I believe you have to give a driver's license number or a passport number, and then a photograph of your driver's license or passport, whichever you use. And this whole system is meant to try to combat money laundering, fraud, sanction evasion, all these companies that are shells that no one can, the federal government or state governments cannot find out who the owners are for regulatory or purposes or crimes. So ultimately, this is going to go forward. I do not think that it's going to be, it's a law and it's going to happen. People were thinking that it was going to get postponed, and it appears that it's not. It is going to go in effect December or January 1st, 2024. How will businesses be notified? You're notified. You have to comply. So there are, like myself, I'm going to assist clients complying with the Corporate Transparency Act, especially all my current customers. I'll be contacting all of them with that. But ultimately, I don't think there's, I'm not aware that the Secretary of State is going to send out any information saying, hey, you guys got to comply. It's FinCEN. It's the Federal Crimes Network is who the filing is with. I don't think they're going to be sending out anything to all the businesses. I just think they're expecting you to know it. There are some exceptions. There's 24 exceptions on who has to comply. Generally, if you're a large business, 20 employees or more, $5 million or more in sales, you do not have to comply. Or if your business is defunct, you haven't had no sales for the last couple of years, no ownership changes, then you don't have to comply. But ultimately, I tell clients, I go, if you're defunct, you're not operating, your business is just sitting there, then my suggestion is just dissolve the business. One, so you don't have to worry about this Corporate Transparency Act exemption compliance issue, and two, for identity theft. If you're not actively operating your business, you are not monitoring it, and identity theft is so rampant that my fear is that ultimately your business is going to get hijacked, and you're not even going to know it, and you're going to have all this debt and credit cards and all these other things happening in your business, and you don't even know about it because you're not monitoring it. So my suggestion is for the defunct or inactive businesses, just dissolve it, be done with it. I had a business that I was me and someone else were looking to try to do something and never worked out for whatever reason. And I'm like, screw it. I'm just going to dissolve it. I'm not going to deal with this exemption because, who knows, FinCEN may come back and say, and do a search of the Secretary of State's website and say, hey, there's all these businesses that didn't comply. We don't know if they're defunct or not. And then they contact you and like, oh, now you have to prove you're defunct or whatever. And I'm just like, it's not worth it. Just spend the time and just, dissolve it. So.
Chris, we are at
But I
the
don't think you're gonna. I don't think you're gonna get it. You're not gonna get any notification. I don't think. It's just they're expecting you to be aware of it, and your professionals to let you know that you have this compliance obligation. Like for myself, if someone's going to create a new business in 2024, I'm not creating the business until my client gives me the information to comply with FinCEN, to comply with this Corporate Transparency Act. I'm not even going to create the business for them. I'm not going to run around and try to chase them and get this information. So.
We are at the end of the hour here. It's our allotted time for the Zoom session. So unfortunately, I'm going to have to cut off the questions and say goodnight to everybody. I am going to put up the slide. Let's close that.
Let me just. This is only things. This is only take a second for this last question. So
Okay.
you would dissolve the business at your Secretary of State. There'd be forms to file with them. So that's it.
I just want to put up the codes here, the QR codes for anyone who wants to get them with their phone. If you didn't catch them at the front end of the session, these are 2 QR codes that you can use. Just point your phone's camera at them and you'll see a link. One link on the left allows you to go to the SCORE Cleveland homepage, so be sure to bookmark that. And the other is if you desire to have a mentor to help you with your small business, on the right, the QR code there will take you to a form where you can fill out on your phone or your tablet or whatever device you're using and request a mentor. And someone will get back to you in a day or two. So I'm going to leave that up for just another minute. I want to thank Chris for a great presentation. I learned a lot. And I don't have a business, so I don't have to worry about that filing requirement, but that does sound like, if you have a business and you need some legal help, this is one of the things that might send you that way. So just to wrap this up, I'm going to close this now. I want to say goodnight to everybody. Thank you all for attending. Chris, thank you so much for your great presentation. And I'm going to close